Good afternoon. We want to welcome you to MyersNave's 2021 Employment Law Update. A few things to get us started for today. This is a webinar style of presentation, so we wanted to let you all know that your microphones and cameras are muted. However, should you have a question for our presenters, there's a Q&A button located in the black menu bar. Please feel free to use that during the presentation or at the end. Our presenters will get to those questions throughout the format and as I mentioned at the end of the presentation. There's also a chat box. Please feel free to ask any tech questions. We did see a question come up. Did we send the slides out? We did not, but we will circulate all our materials either at the end of today or tomorrow before the holiday weekend. Within those materials, you will receive a copy of the PowerPoint presentation, any MCLE credits that were requested, and as well as a copy of the recording for you to pass out to any of your fellow employees. At this time, I'd like to welcome Arlene Yang, and she will introduce herself and our speakers. Arlene, take it away.
Thanks, Stephanie. Hi, everyone. My name is Arlene Yang. I'm a principal at Meyers Nave based in the San Diego office. And I specialize in helping employers to navigate around the complexities of employment law, both through counseling and advice and also in litigation. Most of you here today are clients of Meyers Nave already, but in case you aren't, I'll just give you a little background. Meyers Nave is a full service law firm. We represent public employers, private companies, nonprofits, public-private partnerships, and in a full range of services, including transactions, advice and counsel with employment, litigation, regulatory compliance, and general counsel legal services. We have 5 offices around the state, including in Oakland, Los Angeles, San Diego, Sacramento, and Santa Rosa. Our labor and employment attorneys focus on providing practical advice to employers. We provide day-to-day counseling. We write policies and review handbooks. We do internal trainings, internal investigations, representing grievances, labor relations issues, and also litigation, state and federal courts, administrative, arbitration, so the whole gamut. I am presenting today with 2 of my fabulous co-workers, Gaurav Ahuja and Angelica Pebenito. Gaurav, do you want to introduce yourself first?
Hi, everyone. My name is Gaurav Ahuja. I'm an associate in labor employment group for Meyers Nave. My practice focuses on mostly investigations and providing advice and counsel to public agencies.
Hi, everyone. My name is Angelica Pebenito. I'm an associate in the Oakland office with the Labor and Employment Group and the Workplace Investigations Group. I'm based in our Oakland office. The work that I do for Meyers Nave includes providing advice and counsel to primarily public entities, conducting workplace investigations, and assisting with litigation matters.
Thanks, Angelica. And now that you've heard a little bit about us, we wanted to find out a little bit about you. We have a couple poll questions for you. The first one is just to get a sense of what size organization you're coming from. How many employees do you have? So if you could just take a second and fill that out, we'll get the results in a minute. And then we can also just start to, I can review what we're going to be seeing today. What our presentation is going to cover today. So on our agenda, we're going to be talking about COVID. That could be an hour or 2 hours on its own, but we wanted to give you kind of a quick hits of what are the key issues that you need to be looking out for in 2021. So we're going to talk about COVID health and safety issues. We're going to look at equity in the workplace, compensation and wage and hour issues, and leave and benefits accommodation. And we're going to have some time for questions. Okay, so we have our results and we see that 73% of our attendees have over 100 employees. So it's important to know this information when we're giving employment advice because different rules apply to different size employers. And so we had another question just to find out from you, what's keeping you up at night? What are the biggest concerns that you have? So if you could just check off some of the issues that are concerning you, which ones are your top issues. If there are issues that are not on this list that you think you have questions about, feel free to include it in the Q&A or the chat, and that might be a subject of future webinars as well. So, okay, and so we have our top result is COVID-19 reporting requirements. It seems pretty evenly distributed, a lot of COVID questions though. So we definitely have a lot of time to talk about that here. Thanks for giving us that information. So we're going to move right into our COVID-19 health and safety section. So we have Gaurav to help you with that.
Hi everyone. As the poll showed, COVID-19, is kind of the bear, the bear of everyone's keeping everybody up at night. So we wanted to just ask a poll question. Generally, we wanted to ask if how many of your organizations already have a COVID-19 prevention plan. Just kind of help us guide us a little bit as we discuss this very important topic. So it's 60% of you that voted stated that you already have a COVID-19 prevention plan. That's really good to see. Few of you are working on it and are trying to revise it. That's good to see as well. We'll talk a little bit more about the CalOSHA requirements and what's needed and how we can help you with your COVID-19 prevention plan if you need it. So next slide. So first, we're going to talk about AB 685. As I'm sure all of you are aware, AB 685 is the notice to employees who have potentially been exposed to COVID-19 in the workplace. As the bill states, the notice must be written, and employers have one business day to provide this notice to employees, subcontracted employees, and the exclusive representatives of employees at the work site who have possibly been exposed. This specific notice must include information about COVID-related benefits and the employer's disinfection and safety plan, which has to coincide with the CDC requirements as well. The employer must preserve a copy of these notices for at least 3 years. And when there is an outbreak, the employer must notify the local public health agency within 48 hours. The outbreak is defined as 3 or more employees within the work site. So, when you have a couple of employees who are in the same department, same division, we need to be aware and look out for an outbreak situation, which raises a whole different requirements and concerns, not only with 685, but as you'll see with CalOSHA as well. Next slide. So takeaway for employers, most importantly, employers must have a written letter or email or text, however you communicate with your employees, ready to go when there's a COVID-19 case in the workplace. You want to also make sure that your email addresses, your contact information is up to date, so you can provide that information immediately without having to search for that information. Finally, employers should have a plan or procedure in place to determine how you will notify the public health agency if there is an outbreak in the workplace. Next. Somewhat related to the notice requirements in AB 685 is SB 1159. This went into effect back in September and essentially does 3 things. First, it created a disputable presumption for on-the-job duty injury for all mandatory on-site workers. So this means that employers have the burden of proving that any COVID-19 case that happened between March and 19th and July 5th, 2020, it is on the employer has the burden to prove that COVID-19 related injury did not happen in the workplace. The same rebuttable presumption will now apply to first responders and healthcare workers. As you know, this is the public employment webinar, and we deal with many firefighters and police and peace officers, and so this is very important to be aware of. So what happens? So what this means is employers now have, if those employees obtain COVID-19 in the workplace, it is on the employer's burden to prove that did not occur in the workplace. That rebuttable presumption also applies when there's an outbreak, and as you can see, the definition of outbreak is 4 or more tests, positive tests if you have more than 100 employees, and it's 4% at the location if you have less than 100 employees. What this means is, the last thing this does is it requires mandatory reporting to workers' comp claims administrators within 3 business days when you have a COVID-19 case. Next. So the takeaway for employers is you want to investigate quickly and decide whether to accept or reject a claim. Employers have 30 days to respond to a claim for first responders and healthcare workers, and 45 days for an outbreak. We recommend that you work with your claims administrators and your workers' comp carriers to ensure that you're providing the correct forms for workers' comp and other necessary information to employees. With that, I will pass it on to Angelica Prebenito, who will talk about the daunting Cal OSHA regulations.
Okay, so on November 19th of last year, the California Occupational Safety and Health Standards Board, also known as Cal OSHA, unanimously adopted emergency temporary standards to protect workers from workplace hazards related to COVID-19. The central requirement of these emergency temporary standards are the COVID-19 Prevention Plan, which Gaurav talked about a little bit. But basically, every organization should have a comprehensive COVID-19 prevention plan in place. And there are several different components that must be included in this plan. Some of the topics that are required to be in the plan include a system for communicating information to employees, the identification and evaluation of workplace hazards, such as screening employees for symptoms, identifying conditions and practices in the workplace that could result in potential exposure, investigating and responding to cases in the workplace, physical distancing, face coverings, which we're all familiar with now, adopting site-specific strategies such as changes to the workplace and work schedules. Some of you your organization may utilize the staggered scheduled method. Also, the removal of COVID-19 exposed workers and COVID-19 positive workers from the workplace with measures to protect pay and benefits. And then also the reporting requirements that Gaurav was mentioned earlier. This is a pretty far-reaching, these are pretty far-reaching standards, and they apply to basically all employees and places of employment, with a few exceptions. Workplaces where there is only one employee who does not have contact with other persons, of course, employees working from home, and then employees when covered by Cal OSHA's aerosol transmissible diseases standard. And those include employees who work in certain healthcare facilities, such as hospitals, clinics, medical offices, and does not apply to employees who provide certain services, such as police services, during the transport or detention of persons who may have contracted COVID. And then also employees that work in correctional facilities, homeless shelters, and drug treatment programs. And these standards went into effect, on November 30th of last year. So those COVID-19 prevention plans should definitely be in place. We can go to the next slide. Okay. And then we went over these are the exclusions. So the emergency standards apply to all employees, all places of employment, with narrow exclusions. If we can go to the next one. Okay. So a few takeaways: review your COVID-19 prevention plans. Make sure that they comply with these new emergency standards. Ensure compliance with those standards. Can we go to the next one? And then I'm gonna pass it off to Arlene to talk about trends in COVID-19 litigation.
Great, so thanks, Angelica. As I mentioned in the beginning, I do advice and counsel, and I also do employment litigation. And so what I'm doing every day is I am taking a look at what are the new cases that are being filed in Southern California courts. And we're seeing there's always been a lot of employment litigation. That's one of the biggest areas of litigation generally in the courts. And we're seeing most of the cases that are coming through seem to be pretty similar to they used to be pre-COVID, although there are more cases with a COVID twist. I can tell you that the dynamics in litigation, employment litigation, have certainly changed. I think it was just today or yesterday, the Southern District of California extended their order that they're not going to be having jury trials until the beginning of February. So having this dynamic where there's no jury trials available really changes the dynamic in litigation between the plaintiff and defendant. So the effects of COVID are everywhere, even if it's not in the case, the substantive part of the case itself. But just for employers to think about how to avoid litigation, if you're making terminations, you need to be very careful. There could be COVID related or other ones, but just be careful about who you're terminating and how you're making that decision. We are seeing cases where employees who have fear over workplace safety are suing. And then also we have new leave requirements related to COVID. So some employers may not be aware of it, and that can lead to litigation. And also be very careful about accommodating disabilities. This is a difficult time for many employees. And so employers just have to remember, you have to engage in that interactive process to go through and see if there's a possible way to accommodate. Even if you don't think it's disability, the safest thing is to always think about how to accommodate it or engage in that interactive process. So a few things that you want to keep in mind. And one other thing about COVID litigation I wanted to mention, our firm, Meyers Nave, has a very, very active trial and litigation group and First Amendment practice. So we've seen a lot of COVID-19 litigation that's related to stay-at-home order. So it's not quite employment, but our the head of the trial litigation group, Deborah Fox, is very active in defending public entities who have stay-at-home orders. So that's something to keep in mind. If we go to the next slide, just some things that you want to keep in mind to help to avoid litigation. Having updated handbooks and policies is very helpful, because then the people who are going to be implementing these policies will know what the rules are. If you're using an old handbook, you may be enforcing the wrong laws. We encourage arbitration agreements. There's been a lot of attempts to try to cut that back, but arbitration agreements really help employers to avoid frivolous litigation and also to reduce the amount of risk when you are in litigation, because you're avoiding juries and kind of the much wider swings in possible outcomes that come with jury trial. And then also ensure compliance with wage and hour laws. We've seen many cases where employees are terminated. They think, oh, I was discriminated against. The plaintiff's attorney takes a look at their file and says, oh, no, you weren't discriminated against, but you don't seem to have been paid overtime properly, so we're going to sue about that. So that's the way those issues come up a lot, and so you can avoid that by just ensuring that you're complying with wage and hour laws. If we can go on to the next slide. So we're moving on to equity in the workplace. I wanted to mention, because we had an earlier presentation on Tuesday, and I was asked, why don't you mention vaccines with COVID-19? So we're going to be getting to vaccines in a little bit. But we're going to talk about equity in the workplace next. Yeah. So,
I was just going to say that before we move on, if we can answer a question live on the air, because I think it's an important question, and sure. I've actually dealt with this issue, so I figured before we moved on from Cal OSHA and COVID, someone, I believe Charles Michaels, asked, what enforcement actions have you seen by county health or OSHA, and what it entail? So I've seen one complaint come through for one of my clients that I worked on. The complaint essentially was from an anonymous employee to Cal OSHA saying, after a COVID-19 case positive happened, the employer did not take actions that were supposed to be listed in the Cal OSHA regulations, and they simply required the city or the employer that I worked with to provide a response of what actions we took, what cleaning procedures we took after the COVID case 19 happened, what actions we took to ensure that we were doing everything possible. They gave us 10 days to respond. We provided proof of janitorial schedule, cleaning schedule, pictures of notification requirements, email screenshots that were sent to employees. Basically, everything they asked for. They had a list of things that were complained about, and we sent a response basically answering everything that they asked for. So far, we haven't heard anything back from them. They did say it wasn't a violation, that they weren't going to do an inspection, but that if they found that the response wasn't sufficient enough, they would come and do an inspection. So that's I've only seen it one time so far. I don't know if Angelica or Arlene have seen anything of that sort, but I dealt with that about 2 weeks ago. That was the first time I've seen anything. That's the only one that I know of.
Great, thanks, Gaurav. Moving on to equity in the workplace, if we can go on to the next slide. When I've done these kind of presentations for employment law updates for about 5 years now, and usually a large part of the presentation is focusing on discrimination and harassment, retaliation. Those are still the bread and butter of what we see in litigation cases, and especially in the last couple of years with #MeToo, sexual harassment. But this year, I wanted to focus on diversity, equity, and inclusion issues. As we all know, the killing of George Floyd last year sparked protests related to Black Lives Matter, and it really spurred a lot of conversations with many different kinds of organizations about whether their own workplaces have to make improvements on diversity, equity, and inclusion. So this is still going to be an issue and a hot topic in 2021. I just attended a local county bar association roundtable on racial equity issues, and feelings were very raw. It was just this week, and feelings were very raw about what happened in the Capitol. And it appears that it was mostly white supremacists who were storming the Capitol, and the treatment by the police. These issues are still going to be facing us in 2021. So it's important to think about them. And it's not just the bare minimum about how to avoid legal liability and making sure you're complying with anti-discrimination laws. Companies or organizations that are looking at diversity, equity, and inclusion are looking at, how to change the culture, what kind of policies can you implement to increase diversity or equity within the organization. So those could be things like, for example, if an organization feels like they don't have enough they want to have more Black employees, then they can make special efforts to recruit at historically Black colleges and universities. So there are different steps that people can do or ensure that you have a diverse pool that you're interviewing. There are different steps that organizations can take to try to increase diversity, equity, and inclusion within their organizations. So a couple of takeaways that you can take from on this issue, if we go to the next slide. Those are the takeaways then. And there are more and more studies showing kind of looking at different practices and determining what works and what doesn't. So if that's something you're interested in, please contact us. Then one issue that we hadn't really thought about covering as much when we were started planning this back in November is social media and the First Amendment, but those issues are really coming to the forefront within the last week or so. So we're going to have Gaurav talk about that.
Yeah, and as Arlene mentioned, this wasn't part of our slideshow, and then things kind of picked up at the Capitol, and we were like, this is important, and we also started hearing, some of the individuals that were at the Capitol, were public employees, and of course, I think we as a public agency, I know many of our clients and many of you folks have probably dealt with First Amendment issues with public employees, and so we all know when an individual enters government service that individual has to accept certain limitations on their freedom of speech, but then it does keep their right as a citizen to speak on matters that are public concern. So the essential test is if the First Amendment protection attaches to speech if the speech is a matter of a public concern. That the public concern could be anything, including protests, riots, and things of that nature. Next, we want to see if is the employee speaking about as a private citizen or as a public employee. So if the answer to the first two questions is yes, it's a matter of public concern, and the employee is speaking of private concern. Okay, then next thing we look at is it's called the Pickering balancing test, when we have to determine whether the public employer's interest in making sure that the workplace is efficient and not causing disruption outweighs the privacy rights in the First Amendment speech rights of the public employee, and that's where it gets difficult, right? We're always trying to balance. Okay, well, yes, we have really strong First Amendment rights, but we also, as an employer, want to make sure that we're not that we can still function and be efficient as an organization. And recently, I had to deal or handle an issue with a firefighter who liked a Facebook post of a meme of a truck running over black. It was a pic of a meme of a truck running over stick figures, and it said Black Lives Splatter. And so the concern, we had to kind of go through this test. Okay, well, is it a speech on public concern? Yeah, you're talking about the protest. This is back in May, and then so the next question was it done as a private citizen and is not as a public employee? Well, this employee who was a firefighter had their occupation listed right up there on their Facebook page. So when anybody would see it, they could see that they were a firefighter in this city. So next came, okay, well, what is the you're trying to balance, okay, yes, this person has free speech rights, but is this causing a disruption in the workplace? Is this making our work efficient? What's going on? What's the media? All this stuff you have to kind of balance. So it's a very factor intensive analysis. Next slide. So when those issues come up, you want to make sure that that you want to investigate and do, in fact, we have to do a fact intensive analysis. And I'll let you know that MyersNabe has a very robust investigations team, and we can look at those issues for you. But other takeaways when those issues come up is make sure that off-duty work or off-duty conduct doesn't necessarily mean that it's protected First Amendment speech for public employees. And the next thing you want to make sure is that your social media policies are created and up to date, and kind of outline procedures and policies of how you would handle something like that, or letting employees know that just because they're off campus or off the premises of the property and at home at night, not during the working hours, that they still can be issues in the employment context. Next slide, please. And I will move it over to Angelica to talk about pre-employment inquiries.
Okay, so I'm just going to cover, like Rev said, pre-employment inquiries regarding religious creed, disability, and medical conditions. Employees may have restrictions which limit the hours they are available to work, such as employees who will not work on their day of Sabbath, or employees who cannot drive in the dark due to a disability. The California Code of Regulations were amended to specify what pre-employment practices constitute discrimination on the basis of protected categories such as age, disability, medical condition, and religious discrimination. The regulations forbid employers from making pre-employment inquiries regarding scheduling information to ascertain an applicant's religious creed, disability, or medical condition. Any scheduling inquiry must clearly communicate that the applicant does not have to disclose their scheduling restrictions when they are based on a legally protected ground. Can we move to the next slide? Okay. So a few employer takeaways. Employers should review their employment applications and interview processes to avoid prohibited questions, such as asking employees whether they can't drive at nighttime due to a disability. The DFEH has also approved some language, including other than time off for reasons related to your religion, a disability, or a medical condition. Are there any days or times when you are unavailable to work? And also, other than time off for reasons related to your religion, disability, or medical condition, are you available to work the proposed schedule? So that sort of clearly communicates that you do not have to disclose whether or not whether the reason is based, or if the reason is based on a person's religion or disability. And then also, last takeaway is that you should ensure that online technology does not screen out applicants in a way that has a disparate impact on applicants based on their religious creed, disability, or medical condition. And then if we can move on to the next one. Okay, so before we get into, I guess, one of the big ticket questions, we're just gonna do a quick poll. What is your plan for a COVID-19 vaccination policy? Are you planning to mandate the vaccination in the workplace, offer incentives if employees get vaccinated, no mandate, something else not listed here, or not sure yet? Just give you a second. Okay, can we pull up the results? Okay, yes, so the vast majority of you aren't sure yet, and hopefully we can give you a bit of information to structure your thinking as you, decide within your workplace whether or not to mandate these vaccinations. If we can go to the next slide. Okay. So on December 16th of last year, the U.S. Equal Employment Opportunity Commission, or the EEOC, provided guidance for employers that basically looks at this question: can employers require COVID-19 vaccinations? So just as a quick summary, generally employers may require employees to get vaccinated for COVID-19 and may prohibit employees from the workplace if they refuse to get vaccinated. However, employers should make these determinations on a case-by-case basis, especially if an employee is refusing to get vaccinated due to a disability or a religious belief. One important key takeaway is that in its guidance, the EEOC only describes one scenario where, as a permissible basis to mandate vaccinations under the ADA, which is the Americans with Disabilities Act. And that is that a vaccination mandate in the workplace may be permissible if the employer determines that an employee poses a direct threat to themselves or others by not being immunized. This means that mandating vaccines is only permitted if workers would pose a significant risk of substantial harm to the health and safety of themselves or others that cannot be eliminated or reduced by a reasonable accommodation. Therefore, if an employee is capable of fully performing their current job duties remotely, so working from home, without that obviously negates the risk that they pose to other employees in the workplace. So that in that scenario, it would not appear that employers could require employees to get vaccinated. Okay. And if the employee refuses,
that's only for if it's not if it's a significant burden on the company, on the employer, then they still may be able to say that this is not reasonable. So you have to do that analysis, right?
Right. Then we can, yeah. So as Arlene said, individualized analysis, employers should conduct an individualized analysis that the unvaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health and safety of others. And then one important note is that automatic termination is not permitted. We strongly recommend that you consult with counsel before deciding to exclude an employee from the workplace. Certain accommodations for someone's, if they refuse because of a disability or a sincerely held religious belief, employers are required to engage in that interactive process to determine if there is a reasonable accommodation that they can find. If we can go to the next one. Okay. Right. So employers should plan to engage in that interactive process and lay out a procedure that's communicated to its managers so they know how to identify whether or not a reasonable accommodation does need to be identified through an individualized assessment. Okay. The next slide.
We have a question. One question is, from an anonymous attendee, can you require employees to wear an identifier, like a button, that they have either been vaccinated or not? That's an interesting question. I think that there's a concern here with medical inquiries. So even though you may be requiring vaccines of employees, you cannot be disclosing their medical information. So that information, just like you're not allowed to tell other employees who has tested positive for COVID, you have to be very careful about whether someone's been vaccinated or not is also their medical information. So I would not recommend that.
Right.
Yeah. And also, when you're thinking about mandatory vaccination or not, you have to also think about the wage and hour implications of this. So if, just like we have to ensure that employees are paid for business expenses that they have to incur, if you're requiring them to get the vaccination under California's very strict wage and hour laws, it's very likely that courts would find that the time it takes to get the vaccination must be compensated. And if there are any costs involved, those would have to also be reimbursed. So you have to think about, are you willing to pay for that?
Okay, and then I'm going to pass it over to Arlene to talk about our next topic.
Sure. Oh, and I also just wanted to bring up a couple other issues. So this is a complicated issue about vaccines. So think about what happens if you're mandating vaccines and someone is one of the very small percentage that has a very negative reaction. There may be workers' compensation or other liability involved. And then also the idea of terminating employees who refuse to take the vaccine may lead to litigation and would be likely to lead to some litigation. So you want to think about whether that's something that you're willing to do. So now we're going to turn to compensation and wage and hour issues. This is an always changing area of law. If we go to the next section, we're going to focus on independent contractors first. So just to give you a little bit of background, and I think most of you probably are aware of this, we had this law AB 5 that went into effect at the beginning of last year, and it expanded a decision from the California Supreme Court that was in 2018, which created this ABC test, which made it much more difficult for employers to hire people as independent contractors. So then September of last year, after that came into effect, there was a lot of lobbying and a lot of bills going through the legislature. And the one that made it through was AB 2257, which added some exemptions to AB 5, but left it essentially intact. And we'll talk about a little bit about what's in that. And then there was also Proposition 22, which was a bill that a law that was paid for by the Uber and Lyft, and it only focused on app-based drivers. And so it's important to keep abreast of what's going on there. Just this week, we had 2 new developments on this law. Just today, there was a Supreme Court decision from the California Supreme Court finding that Dynamics is retroactive. So even though employers had no idea about this ABC test, it will be retroactive. And so activities that occurred before Dynamics could still be considered in violation under this ABC test. So that's not going to affect a lot of cases right now because the statute of limitations has been moving along, but that's a big decision. And then also just yesterday, some Uber or app-based drivers and unions filed a writ of mandate in the California Supreme Court to try to overturn Proposition 22. So this area of law is still moving quite quickly. If we want to move ahead, so this provides some of the areas in which AB 2257 changed the law. There are more professional services exemptions. It has more ability for entities to use a business-to-business exemption for business service providers. And I understand that a lot of our public employers have been able to use this exemption with some of their workers. And then if we go on to the next slide, I have to kind of run through this quickly because we don't have a lot of time, but just generally, I'm not going to go through the whole thing, but generally when we're going through the process of looking at whether someone can be classified as an independent contractor, we're going to start with the ABC test. And if you can't meet those 3 conditions, then we have to move and see if there's an exemption. So if we go to the next slide, this is sort of a summary of all the different types of exemptions that might be available. So I would typically look at the employing entity and the worker and see if any of these individual exemptions apply. And then we go into the next step. So this is the beginning of the year. It's a good time for you to take a look at your independent contractor relationships, reassess whether you might need to reclassify some people, and just know that it's important to stay abreast of these issues. If it turns out that someone's determined to have been misclassified, then the employer has not been keeping track of overtime hours, providing meal periods and rest breaks, paying for unemployment or other types of insurance that are required. So it can lead to quite a bit of headaches and expense in trying to resolve things. So we just encourage you to try to get abreast of it and act preventatively and proactively. And next slide. And then another issue just to consider is that you don't want to have no rehire clauses in settlement agreements. This law first came into effect last year with AB 749, which prohibited no rehire clauses in settlements. The legislature was of the opinion that this was restraining trade and people's ability to do their professions. They did have an exemption for sexual harassment and sexual assault. So you could have no rehire provision if the employer believed that that had happened. So we have this cleanup bill that's effective this year, which expands AB 749 so that if someone is engaged in criminal conduct, the employer can also use the no rehire provision. And then there's a couple rules to try to prevent gamesmanship. So if the employer is going to say, for example, this employee engaged in sexual harassment, so we're including the no rehire settlement clause, they must have documentation of this bad conduct before the claim was made by the employee. And similarly, if the employee is going to say that this was not appropriate, no rehire clause, their complaint or claim must be in good faith. So just some things to keep in mind when you have settlement agreements. And this is, so when we go to the takeaway on the next page, just to keep in mind, this is only when there's an employment dispute. So if there's been no employment dispute, you can still have the no rehire clause. And employers are not required to retain or rehire unfit employees. And yeah, so those are the issues to keep in mind. And we're going to go on to the next section, which is minimum wage, and that's going to be Gaurav.
Yeah, I'm going to talk quickly about the minimum wage increases in California and its effect on exempt employees. So effective January 1st, 2021, California raised its minimum wage for employers with 25 or more employees, 26 or more employees. The minimum wage has increased to $14 an hour. For employers with 25 employees or less, it's increased to $13 an hour. This affects California's minimum salary requirements as well for exempt employees to qualify for the white collar exemption. So for employers with 25 or less employees, the minimum amount of salary to qualify for the white collar exemption is $54,080 a year, and for employers with 26 or more employees, it is $58,240 a year. Next slide. So quick employer takeaways regarding the minimum wage increases. Employers should update minimum wages and minimum wage postings to meet the new requirements. Employers should ensure that exempt employees' salaries satisfy the minimum salary requirements. And for kind of keep in mind that even if you have part-time employees, for them to qualify as exempt employees and the white collar exemption, they still must meet the minimum threshold for the salary requirements. I also want to point out that different localities also have their own minimum wage requirements. So if you want to check your local ordinances in your locality's minimum wage when you're making these changes as well.
Right, although the minimum wage, the minimum salary requirement for exempt employees is based on the California standard.
Next slide. The next topic I want to talk about is the minimum compensatory time. So this has to do with the Frelkin v. Apple case that was decided in 2020. This is a case where Apple's retail workers were spending time after work getting their bags checked, and they filed a class action suit that went all the way up to the Ninth Circuit to get paid for that waiting time while they were waiting for their bags to be checked. The Ninth Circuit ruled in favor of the employees and said that Apple had to pay these employees because the searches were required. The searches, Apple had significant degree of control over these employees while their bags were being searched, and that they were enforcing the bag searches through a threat of discipline, and that the searches were imposed primarily for Apple's benefit. Although this case was a private employer case, the wage orders that were issued do apply. One of the wage orders do apply to public agencies, so it does provide some guidance about how it affects public employers. Next slide, please. I actually had a research question related to whether temperature checks or waiting time for temperature checks would qualify, and using this case and other similar cases that have come down, we recommended that the public employer should ensure payment of every minute the employees worked, including temperature checks if it's taking waiting time, if it's taking a long time for the temperature checks to occur. So for employers, the quick takeaways are: you want to determine employees have unpaid activities related to the work. And again, this includes temperature checks, donning and doffing, any non-generic protective gear. You want to ensure that every minute is paid that an employee works. You want to establish policies and training that off-the-clock work is prohibited as well. Next slide. Next topic that has come up a lot in the public employment context with the labor code is employment reimbursement for telework expenses. So California Labor Code 2802 specifically states that private employers are required to reimburse California employees for all necessary business expenditures or losses incurred by the employee in direct consequence of the discharge of the employee's duties. This is to ensure that employers don't pass operating expenses to employees. And the key here is that the reimbursement is for necessary and reasonable costs only. And case law and other guidance has stated that this includes cell phones, internet, or other electronic items and furniture for work. So the question always has come up: does Labor Code 2802 apply to public agencies? And the answer is it's unclear right now. There is one case that sort of hinted or applied 2802 to public agencies, but that did not specifically state whether it does or not. So what the recommendation has been, or the guidance has been from what I've seen and from many agencies, are providing public employees with reimbursement for necessary items such as printers, office chairs, other things that are required, especially if they're forcing these employees to work at home. Again, you want to make sure. Next slide, please. You want to make sure that these reimbursements are for reasonable expenses. So your employers are encouraged to draft a reimbursement policy that will manage the expectations about which business-related expenses may be reimbursed, and you want to establish procedures to allow reimbursement. Next slide, please. Then we'll move on to the leaves, benefits, and accommodations section, and I believe that Angelica will be taking on next slide.
So we're going to talk about SB 1383, the expansion of the California Family Rights Act leave to small employers and inclusion of more family members in the definition. I just want to preface this with while there's an employee threshold, so the number of employees that is part of this law, that's only for private employers. The two laws that I'm going to be talking about apply to public employees regardless of size. So previously, employers with less than 50 employees within a 75-mile radius on the work site did not have to worry about providing protected unpaid family and medical leave or the California Family Rights Act. Similarly, employers were only required to provide baby bonding leave under the new Parent Leave Act if the employee worked at a site with at least 20 employees within a 75-mile radius. That's changed now. For private employers to be 5 or more employees, but like I said earlier, this applies to public employers regardless of size. The new law would also affect large employers who previously did not have to comply with the CFRA because they didn't have 50 or more employees within 75 miles of the work site, which would still apply here. The CFRA revisions did not change the requirement that to be eligible for leave, the employee must have 1,250 hours of service with the employer during the previous 12-month period. In addition, the law changed to require that an employer that employs both parents of a child grant leave to each parent, which was not previously required. Furthermore, starting January 1st of next year, family member, the definition of family member under the CFRA will expand to include grandparent, grandchild, and sibling. It previously only included the employee's parent, child, spouse, or domestic partner. If you can go to the next one. Okay, and then the next one. That. And then just a couple of quick employer takeaways. Employers should update forms, documents, policies, and employee handbooks to account for the changes to the CFRA and the baby bonding law. For public employers, I would say that the definition for who constitutes a family member should be updated in your handbooks. We can go to the next one. Now Gaurav's going to talk about the Family First Coronavirus Response Act.
Yeah, just quickly, as we all know, everyone had to deal with the federal FFCRA that was passed by Congress after the COVID-19 pandemic became real for all of us. So just want to point out quickly that recently Congress extended the ability for employers to provide this leave. However, for public, this was done essentially for private employers who could use that if they voluntarily provided that leave to earn payroll tax credits until March 31st, 2021. If private employers voluntarily continue to provide such leave. For public employers, are ineligible for the tax credit. So, but I have some of my public agencies have definitely extended such leave, and they've kind of reconfigured it to either providing just emergency paid sick leave and not providing the emergency paid family leave. So it's next slide, please. So the takeaway, really quick, for public employers is you want to determine whether you are extending the FFCRA or not. You want to communicate those changes in policy to employees. Please note that the current FMLA unpaid leave still exists and can still, employers can still use that. And for under the ADA, leave is still, may be possible as a reasonable accommodation and may be required if FMLA leave is exhausted and not available. Just a quick note: if an employer has already provided the FMLA or EPA, emergency paid sick leave, and an employee has exhausted that leave, employers are not required to give anything in addition to what has already been exhausted. Next slide. And I'll give this to Angelica to talk about the California corollary to the FFCRA.
Okay, I'll just cover this really quickly since I know we're running out of time. AB 1867 is the new COVID-19 supplemental paid sick leave that was intended to close a loophole left by the Family First Coronavirus Response Act. So AB 1867 established supplemental COVID-19 paid sick leave for private employers with 500 or more employees, as well as public and private employers, first responders, and healthcare employees who opted out of the leave under the federal law that Gaurav just spoke about. Like I said, this portion of AB 1867 was intended to fill that void left by FFRCA. And if the employer has already provided employees with paid sick time for the same COVID-19 related reasons, then the employer is already in compliance. This law expired on December 31st of last year. And then I just wanted to recap that this applies to public entities that employ healthcare providers or emergency responders when such public agency has elected to exclude such employees from emergency paid sick leave under the federal FFRCA law. If you can go to the next one. So because the law expired on December 31st of last year and the FFCRA no longer requires paid leave, no additional leave is required to be provided in 2021. Okay, and then I'll pass it over to Arlene.
Great. And so just the last section, I want to spend 1 minute to look ahead to the Biden administration. Here in California, because we have such strong protective laws that are in California, and the most protective laws are the ones that apply. Typically, we don't have to worry too much about what's going on in Washington because whatever they're doing is often less protective than what we have already in California. So we won't see a lot of changes day to day in what we're seeing, but we will eventually see changes in the agencies as they're having new priorities over time. And also with the Democratic Senate, we can expect additional legislation that's going to be more employee friendly. So just keep that in mind. I wanted to spend, because we have just a couple minutes left, we did have some questions and I wanted to make sure we have time to answer a few. So Gaurav, there was, or Angelica, there was a question about may employers from Mei Xing Yang, may employers require employees who report a COVID positive 19 test to submit supporting medical documentation for confirmation. It seems permissible under Cal OSHA regulations. Do one of you want to take that question?
Yeah. The employers can ask employees to require to show proof that they have tested positive for COVID-19. But employers should be wary about asking any additional questions, and in case that any of those subsequent questions may trigger implications under things like the ADA.
Right, and you're going to want to have policies in place to ensure that that information remains confidential. It's not disclosed to other employees. It's really only on a need-to-know basis. And so this is an interesting question. To what extent can employees ask to work only with those who have identified as having the vaccination and to keep others not vaccinated or don't want to disclose in a separate area? I could see a lot of problems with that. We could talk further and figure out how that might work, but I could see a lot of problems with trying to enforce that, especially where we're not permitted to disclose who has the vaccine and who doesn't. I don't know if Gaurav or Angelica, you've seen that issue come up yet, but I think we're talking about having another webinar just focused on vaccines because there are so many issues that we need to consider. So hopefully, feel free to reach out to us if you want to discuss these issues further. So we're running out of time right now. I forgot one thing that I forgot to mention in the beginning, because this was a legal information session. It's not intended to be legal advice. So that's our disclaimer. And also just to be aware, as you know, these laws are changing rapidly. So we're telling you the information that we have today, but if you're watching this on webinar or something, this information may be changing very soon. Thank you for joining us today. Feel free to reach out with us with any questions. We're here to help, and we'll see you soon. Thank you.
Thank you all for joining us. We appreciate you all and your questions. We will circulate all of the materials by the end of the week. Take care.